Biggest little city in the world, right?
Yes.
So we will introduce ourselves. We'll ask you to introduce yourselves and your teacher, and then we'll get going this morning. My name is Ben Glickman. I'm a Deputy Attorney General with the state of California. I represent the state and state officers in a variety of civil litigation around the state. Also an alumnus of the program. I was on a national championship team way back in 1995.
My name's Rita Burns-Kittle. I work for the Equal Employment Opportunity Commission, so I supervise 7 lawyers litigating in 4 states.
I'm Donald Rogers. I teach history at Central Connecticut State University in New Britain, Connecticut. My favorite course is legal, Anglo-American legal and constitutional history. So I'm looking forward to hearing some of your comments, and maybe I can learn something to put in my course. And I was remarking when I came in, we have a pretty energetic group here, and that's my feeling. That's always a good class. And when there's a lot of energy, then you know there's a lot of ideas. So looking forward to the presentation.
Good morning. We're from Reno, Nevada, Reno High School. I'm Carmen Stewart, and I will be attending the University of North Texas. I'd also like to introduce our 5th member, John Mendelson, who had to have emergency surgery for blood clots and road removal.
Good morning. My name is Tommy Brooksbank, and I will be attending the University of Southern California in the fall.
My name is Kelsey West, and I will be attending San Diego State University.
My name is Jacob Wade. I will be attending the University of Arizona this upcoming fall. Our unit coach is Scott Daniel, and our teacher is Richard Clark.
Colleague doing all right? Everything okay?
Yeah.
Yes.
Good.
We'll just assume he knows anything you don't. Whenever you're ready, you may begin. Oh, I have to do the question? Which one do you want to do? No. The question this morning is number 1.
That's the one they wanted.
How do the 2 alternative conceptions of rights, as negative or positive, reflect different beliefs about the role and responsibility of government in securing the rights of people? How are ideas of negative and positive rights reflected in classical republicanism and in natural rights philosophy? Why do these alternative conceptions of rights, as negative or positive, frequently generate conflict, and what historical and present-day evidence can you cite?
John Locke declared in his second treatise, the end of law is not to abolish or restrain, but to preserve and enlarge freedom. For Locke and the founders, freedom meant negating the government's power to intervene in our private affairs. Today, however, many interpret the social contract to require the government to actively confer positive benefits to improve our quality of life. Negative rights directly limit government power and give individuals rights, whereas the alternative concept of positive rights require that the government must act in a specific way. The Sixth Amendment's right to counsel emulates these qualities of positive rights. In contrast, the qualities of a negative right can be seen in Article 1, Section 9, which prevents the government from restricting the writ of habeas corpus.
In Gideon v. Wainwright, the courts had the responsibility to provide a defense counsel to Gideon. The government was required to provide a service to the defendant so that he may maintain his rights. The positive rights seen in this case represent a vision of a government that provides for its people through the government intervening in citizens' affairs. Another example of this ideology of rights is the Social Security Act. Because the government provides a service that only benefits the people, it is labeled a positive right. In contrast, negatives imply that the government ought to have restrictions placed upon it. This is seen in the phrasing of the First Amendment, stating Congress shall make no law, emphasizing the restrictions it is putting on governmental power.
In the 2011 case Bond v. U.S., the court ruled that the Border Patrol agents weren't allowed to physically manipulate Bond's carry-on bag since they didn't have a warrant. This case brings into question the issue of the objective view versus subjective view of privacy, and represents how the government is restrained from acting in a specific way.
The influence of negative rights is reflected through the classical Republican belief seen in the eminent domain clause of the 5th Amendment. It states that private property can be used for public use so long as there is just compensation. In 1984, the court ruled on Housing Authority v. Midkiff, stating that the Hawaiian Housing Authority was able to take the property from Midkiff because they paid just compensation to him before taking it.
Both positive and negative rights attempt to secure the rights of the people, but provide separate approaches. These alternative concepts frequently develop conflicts because they take different approaches to protect individuals' interests. As the political theorist Isaiah Berlin stated in 2 Concepts of Liberty, negative liberty means freedom from, positive liberty means freedom to. The former is the realm of individual self-determination. The latter addresses the area of institutions and rules which can supply or deny the means through which individual goals are attained.
The government of the United States exists to provide citizens with both a sense of security and personal liberty. It is important for the government to provide a healthy balance of these two goals by providing both positive and negative rights that prevent anarchy or totalitarianism from occurring. Constitutional justification of the national government's involvement in public education rests with the expansion in congressional power that occurred during the progressive era of the early 20th century. The movement provided more tax money to be spent on programs for the general welfare of citizens, such as education. However, education did not become a negative right until Brown v. Board of Education.
After the ruling of this landmark Supreme Court case, national financial aid for public schools has become a permanent aspect under the Department of Education. President Lyndon Johnson's Great Society boosted federal spending on elementary and secondary education. This funding has continued today through President Obama's controversial categorical grant, Race to the Top.
Another example involving the conflict between positive and negative rights is the current healthcare debate. National Federation of Independent Business v. Sebelius has called into question whether the law executes positive and negative rights effectively. The founders saw the only way to truly secure the rights of the people was to balance the role and responsibility of the government through the use of both positive and negative rights equally. Thank you.
Okay, let's talk a bit about positive rights. Can you point me to some additional areas? You mentioned the Sixth Amendment. Can you point me to some additional areas in either the Bill of Rights or the rest of the Constitution where we find positive rights?
The entirety of Article 1, Section 8 is a positive right. It says that Congress shall make laws such as the right to impose taxes.
You can really look to the entire Constitution without the Bill of Rights as a positive right, as it's framing a government that we wouldn't have a government without the Constitution, and the only part where it's really restricting any governmental power is Article 1, Section 9.
An example of a positive right is in the 22nd Amendment with term limits on the president, and it also relates back to a negative right for the people because it is a check on the presidential's power.
Can you explain how that is a positive right?
It's a positive right on the president because it is because he is part of the government, it is forcing him to act in a certain way, so he's not infringing on the rights of people.
What about the general welfare and necessary and proper clauses? How would you interpret those in terms of negative or positive rights?
It really depends on the way you can use it. Necessary and proper can be a positive right, as it's, for example, the Affordable Care Act that was just passed. It could be a positive right because we see it as the government needing to provide a service to the lacking of healthcare that many Americans have. But you can also look to it as a negative right, as it is making healthcare a fundamental right that citizens have, and the government cannot take that away.
Another example with the necessary and proper clause is education and Obama's Race to the Top categorical grant, which has increased the Common Core debate to improve education and the classical Republican belief that everybody needs to work toward the common good. So states have began to incorporate that in order to receive the grant to improve their city.
Let me ask you about, you mentioned in your opening remarks about the Social Security Act as an example of a positive right. So is that in the Constitution, or what is the authority in the Constitution for the creation of Social Security?
I would look to the necessary and proper clause as well. This was when the Social Security Act went into place. It was at one of the darkest points in the country's existence. We were going through the Great Depression, and there wasn't any economic stimulus, and the majority of Americans were still living in poverty. And this was one of the programs that President Roosevelt put into place in order to try to bolster the economy again and get people back onto their feet so we can have a more effective society in America.
Branching off what Tommy said, it was with the necessary and proper clause. It was meant to shed, when prior to it we were negative rights. Now it's a shift to the focus of positive rights with the New Deal being implemented, such as the Agriculture Act that was implemented as well.
Do you see the 14th Amendment at all affecting the application of positive or negative rights? 14th Amendment.
I think the 14th Amendment definitely affects positive and negative rights because before the 14th Amendment, most of the Bill of Rights were political and not they were only applied to the federal government, but after the 14th Amendment's incorporation, it applied to the states directly, and now the people felt as though these rights were not only political, but they were to protect themselves.
And exactly which rights are we talking about?
We're talking about rights such as rights, like for example, the right to vote, and it makes it all the rights equal under that you have equal protection under the law from the government.
You also can see that the Equal Protection Clause of the 14th Amendment provides the equality of opportunity for all citizens, and in the fact that they all deserve to achieve their goals, but some may not be able to achieve them.
Now, which branch of the government enforces the Equal Protection Clause of the 14th Amendment?
We can definitely see the enforcement of the Equal Protection Clause of the 14th Amendment through the courts and the precedent that they set in their decisions.
You can also see you can also see the enforcement power that rests with the president, because although the judiciary system can make the president has the overall enforcement power, and that's not, he can decide not to enforce something, a statute that the Supreme Court puts into place, and then it would become ultimately void.
How about the power of Congress? Does Congress have a role in enforcing the 14th Amendment, the Equal Protection Clause?
Yes, they definitely do. Most of the bills have to go through Congress first, and they can do it through bills and statutes put into place that can change the way that the society exists. For example, the Civil Rights Act of the 1964 emphasized that.
Right. Is that a negative or positive right?
You can look to it as a positive right because it's the government providing for the people equality under necessary and essential services that we need in society to function, and it's still letting some people protect the government from becoming overbearing, but it's providing positive rights for the necessary people that are being discriminated against.
Any positive rights you think we should add to our federal constitution?
Sorry, could you just repeat?
Yeah, are there any positive rights you would add to the federal constitution?
A positive right I would add to the federal constitution is a better definition of what the papers are in the Fourth Amendment.
Thank you. We're out of time, unfortunately. Thank you. All right, nice job. We'll give you a little bit of feedback on the presentation and the question and answer. I thought the presentation did a nice job. There were 2 points that I particularly enjoyed. The first was when you brought it to today. You said today the social contract, many view the social contract as requiring more positive rights. And I thought that was a good way to distinguish between kind of Locke and the framers' view versus how we're looking at it 200 and some odd years later. And the second part I really liked is hearing Isaiah Berlin get in there and the 2 conceptions of liberty. That's obviously relevant to this question and a key kind of theory underlying these issues. So I appreciate hearing that. On the positive rights, I think we struggled a little bit with finding the positive rights in the Constitution, and I think the reason we struggle a bit is it's not necessarily black and white. I think it depends on from which side you're looking at it. A negative right can be viewed as positive depending on how you're looking at it. And so what I would encourage you is to be as precise as you can be in where we're finding these rights in the body of the Constitution or in the specific amendments. And where it's not clear, to say that. To say, well, it's both. It's positive and negative. It all depends on how you analyze it. And so overall, you had the substance. It's just now drilling down and really getting the specifics. So nice job.
Well, and I echo that. I thought it was a very nice presentation. I like that you talked about the eminent domain. I would add to that the takings clause. I think the 2 go together, and you should talk about them both. And then I liked how you talked about public education, Brown versus Board of Education, and bringing that forward in history through LBJ and the race to the top stuff. I thought that was a nice example that you used there. And then just to echo what Ben said, the the perception of the rights is often different than what the language is. So one of the best examples of that is the Second Amendment, and people believe vehemently that they have a right to have a gun. When you read the language, which sounds like a positive right, when you read the language, it is clearly written as a negative right. Now, so does that mean it's positive, or does that mean it's negative? My only advice is start with the language and deal with it from the language first, and then talk about it in terms of how it's perceived by people, or ways in which it may have sort of mutated into a positive right of some sort. But nice job, you guys.
I really enjoyed your presentation. I thought you made a very, very strong case for the development of what might be called the social welfare state. You provide an enormous amount of evidence about how that's evolved all the way down to the programs of President Obama. I thought that was a real strength. I also enjoyed the eminent domain example. Although being from Connecticut, I just was disappointed we didn't hear about Hilo versus New York, which of course came after the Hawaii example, and it was a very, very controversial case in Connecticut, believe you me. On the 14th Amendment, I thought that it was a real, we worked through it, we came up with a good answer. We couldn't nail down a few more of the specifics as Ben suggested. 14th Amendment doesn't secure the right to vote. That came with the 15th Amendment. The Section 5 of the 14th Amendment gives Congress the power to enforce the other provisions of the amendment. So that sort of is an area where it might see a positive right. And we sort of got to that as we worked our way through, and I appreciated that. One final suggestion on the Social Security Act. I thought that the good, excellent question about under what authority in the Constitution was that enacted. I think that's under the taxation clause, because the Social Security involves taxation. So that would have been helpful to nail that down. But again, I agree with the general thrust of my colleague's comments. Overall presentation was excellent, particularly the development of the social welfare state. And just nailing down some of the specifics would make this just an absolutely outstanding presentation.
Thank you.